This module explored the foundation of employment relationships in Arizona real estate, emphasizing the legal framework, required contract elements, and case law that governs broker compensation. Every real estate professional in Arizona must operate under a written employment agreement with their designated broker before conducting any licensed activity. This written contract, as required by ARS, paragraph 32, 2 and Commissioner's Rule R428-306, defines the broker-licensee relationship, including the method of compensation, supervision, and termination procedures. It also determines whether the licensee is classified as an employee or independent contractor, an important distinction affecting both liability and tax responsibilities. The module highlighted that all real estate employment agreements, including both listing and buyer-broker agreements, must contain certain required elements: a definite expiration date, signatures of all parties, identification of the property and parties, compensation terms, and a clear grant of authority for the broker to act on behalf of the client. Agreements missing these elements or containing prohibited terms like automatic renewals are considered void and unenforceable. Optional or non-required elements, such as cancellation clauses, dispute resolution terms, or dual agency disclosures, are often added for clarity and risk management, but are not mandated by law. You also learned that Arizona law defines broker compensation through both statutory rules and contract performance. Under ARS, paragraph 32 5, a broker earns commission only when the conditions outlined in the written agreement are met, and all payments must flow through the employing broker. In practice, compensation may be tied to a successful closing, the production of a ready, willing, and able buyer, or another specific milestone outlined in the agreement. The broker's right to commission may survive a failed closing if the client acts in bad faith or cancels the transaction after the broker has performed in accordance with the contract. Different types of transactions: sales, leases, buyer representation, and referrals carry unique compensation structures, but all rely on written documentation for enforceability. Listing transactions usually pay upon closing, leasing transactions upon execution of a lease, and referral fees upon the cooperating broker's closing. Arizona's commercial broker lien law, under ARS, paragraph 33, 1071, also provides additional protection for brokers seeking unpaid commissions on commercial property. Finally, this module tied these principles to key Arizona case law, each reinforcing the same central truth: brokers must act lawfully, ethically, and with written proof of their agreements. Mealy v. Orlick, 1978, confirmed that without a written employment agreement, a broker cannot recover commission, even with full performance, because the Statute of Frauds, ARS, paragraph 441017, requires written, signed contracts. Larson Hagstrom v. Jeffries, 1985, affirmed that a broker earns a commission once they produce a ready, willing, and able buyer under the agreed terms, even if the seller later refuses to close. Demand v. Foley, 1970, ruled that a broker is still entitled to commission if the client acts in bad faith to prevent the transaction from closing. Nash v. Score, 1963, established that dishonesty or misrepresentation forfeits a broker's right to compensation, tying legal compliance directly to ethical conduct. Clark v. Ellsworth, 1947, reinforced the ready, willing, and able doctrine. When a broker fulfills their duties under the employment contract, the commission is earned regardless of the seller's later refusal to sell. Mohammed v. Robbins, 1975, clarified that all compensation must flow through the employing broker to maintain accountability and compliance with ARS. Paragraph 32, 21-5. Together, these statutes and court decisions form the legal and ethical framework that protects both brokers and clients. Written agreements are not merely procedural. They safeguard professionalism, define expectations, and ensure fair compensation based on lawful performance. Retention tip. Remember that in Arizona, no written agreement means no commission. Brokers earn compensation through performance as defined by contract, not by closing alone. Good faith, full disclosure, and supervision are as vital as written compliance. Key takeaway. Arizona's employment agreement laws balance structure and fairness. They protect the broker's right to compensation while ensuring ethical conduct, transparency, and accountability. Understanding how statutory law and case law interact equips brokers to manage relationships confidently, minimize disputes, and operate with the professional integrity that defines the Arizona real estate industry.